Hello guys, so before I begin with the treaties in this video, I would like to mention Article 59 that had the role to play when we were doing Article 38 one of ICJ rules, right? So Article 59 is also of ICJ rules, and now let's see what it talks about. Decision of the court. Here court refers to the international court, of course, and for this matter court is ICJ only. ICJ के rules है. Even if I talk about the Indian courts, then High Court and Supreme Court can also, for their administration and proper functioning of the courts, it can also formulate some rules and procedures. Okay, so similarly ICJ has its rules, and out of those rules we had did article 38 and now article 59. It says that decision of ICJ has no binding force except between parties and respect of that particular case. So whatever case is there and the parties to the dispute, here parties is basically the nations or the governments of two or more nations which are parties to the dispute or parties to the particular case, उन पर ही सिर्फ बाइंडिंग होगा, but they can also claim their sovereignty, so they can also refuse to be bound by it because of the sovereign nature of almost every nation today in the world, and otherwise it has no binding force. Now what is the significance of this? Like the rules or principles which are set by the Supreme Court, it has a binding force on all the citizens of India, right? And also on the high courts. And we say that Supreme Court has settled the position on a particular piece of law or on a law point, and it is settled by way of precedence, right? Precedence. Wait a minute. Right, that is the settled piece of law. Why it is settled? Because we have the binding force of judgments of Supreme Court, and as far as High Court is concerned, then it is also having the binding force regarding the territorial jurisdiction of that particular state of which it is the High Court, right? Okay, so this was Article 59. Now let's come back to our legal books. See over here. Here we had Article 31 yesterday, and this is Article 59. Okay, so that's what I have discussed right now. I hope now that is clear. Then we will come on to treaties, that is the sources of international law, and no hierarchy is there. That means just that treaty is written first, then treaty is to be considered or given more preference than conventions or than customs. ऐसा कुछ भी नहीं है, ठीक है? They are generally applied with no preferential rule as such. Treaty, international convention or charter refers to legally binding written agreements in which states agree to act in a particular manner as specified in the agreement. Even if it's a basic agreement or contract, the thing is that both the parties to the contract decide that what will be the terms and conditions of the contract, or what they are buying, what quantity, quality, right? All the specific details of the goods which are the subject matter of the contract are written in that agreement. Also the details of the parties' names, address, mobile numbers, credentials, all such are also provided. And it is also provided that if this particular quantity of good has to be sold, then by which date it has to be given possession or delivered to the buyer, right? And by what date the payment has to be made to the seller, right? And in what mode, cash, check, या डिमांड ड्राफ्ट, जैसे भी होगा, किस मोड में पेमेंट होगा, कब तक होगा, इंस्टॉलमेंट्स में होगा कि सारा एक बार में कर दोगे, दैट इज़ ऑल व्हाट टर्म्स एंड कंडीशंस ऑफ द कॉन्ट्रैक्ट, और टू से दैट the manner in which they are to execute or they are to work as per the contract. Okay, so this treaty also, now I have given you a very basic and simple example of a simple or the most easiest way of a contract to make you understand what a treaty is and what is its function. So a contract is also a legally binding transaction, and it is a very serious transaction in the sense that Anson was wait a minute. Anson, he said that contract is like a lighted matchstick is to gunpowder. ओके, मतलब अगर गन पाउडर के पास आप जली हुई माचिस लेकर जाओ, लाइटेड मैच स्टिक, तो क्या होगा, जल जाएगा, ब्लास्ट हो जाएगा, डिज़ास्टर, राइट. सो दैट सीरियस ऑफ अ ट्रांजैक्शन इज़ अ कॉन्ट्रैक्ट. ओके, हैविंग सेड दैट, legally binding, okay, written. Now written basically is important if you are to retain it as a record for future reference. Okay, so that's why, and it's between or among nations of the world, so it's convenient and as a matter of practice to be in written form only, not orally. ओरल से एक ये भी पॉसिबिलिटी होती है कि थोड़े टाइम बाद, since it is of course no record of it, so people can also refuse or they can also retaliate that no, I haven't promised such thing, I haven't said that I will do this, right. So they may, refuse to act in a particular manner which they have earlier promised or decided to someone. इसलिए written होगा, legally binding होगा, because if it's not binding then there is no use of making that contract or treaty, right. It will be futile, वेस्ट हो जाएगा, फ़ायदा नहीं है अगर उसके पास बाइंडिंग फोर्स नहीं है. इसलिए जो भी ट्रीटी है उसमें अगर कोई कंट्री पार्टी बन रही है, मतलब उस ट्रीटी को साइन कर रही है या रेटिफाई कर रही है, तो सोच समझ के करना होता है, बिकॉज एज सून एज यू हैव डन दैट यू हैव टू इम्प्लीमेंट द प्रोविजंस ऑफ दैट ट्रीटी और कन्वेंशन इनटू योर ओन डोमेस्टिक लॉज ऑफ योर नेशन. ठीक है, एक आप पर वो ड्यूटी कास्ट हो जाती है एज सून एज द कन्वेंशन इज़ रैटिफाइड and the states agree to act in a particular manner. What is the manner? Which is specified in that agreement itself. Okay, as I gave you the example. Treaties are often complex documents. Complexity obviously arises from the fact also that it refers to the manner in which many nations have to act, right, or many nations have to work accordingly. सो जहाँ इतने ज़्यादा लोग इन्वॉल्व हो जाएंगे एंड एवरी नेशन हैज़ अ कॉम्प्लेक्स हिस्ट्री, हैज़ अ डिफरेंट रूल्स, प्रोसीजर्स, लॉज, customs, and the way in which the people of native people of that country live, the climatic conditions, atmosphere, the manner of living, standard of living of those people, everything is different. The economic conditions, social, political, and the development status of each country is also different. So obviously if it is an international law regime, it is a complex one. With regards to those involving more than two parties, as they are binding upon them and are to be entered into in good faith. Of course good faith hona chahiye, good faith in the sense that you have the intention of obeying it, okay, because it is legally binding, you have to obey it. सो विद गुड इंटेंशन यू हैव टू जॉइन. ऐसा नहीं है कि हमें बस लाइक फॉल्स अपना एक इमेज पोर्ट्रे करना है इन फ्रंट ऑफ द वर्ल्ड दैट आई एम वेरी अटेंटिव एंड आई एज अ नेशन आई एम वेरी concerned about the environment, so I am signing this particular treaty, or concerned about the particular issue with which that treaty is concerned, and on the face of it or on the actual level I'm not at all concerned with it. I'm not gonna obey it, I'm not gonna implement it in my laws, okay, just for the sake of it, to show it, to masquerade to the whole world, I am ratifying it. So I have used the term masquerade. That means दिखावा करना, अपना एक false mask दिखाना लोगों को, ठीक है? Okay. So that has to be entered into in good faith. That is to say that person is going to obey it. Otherwise there is no use. And complicity arises, as I said, because more than two parties are involved and it is also binding upon those parties. So it is difficult to see that whether the parties are actually, obeying the foundations or not. They are actually being complied by those foundations or not. Agreements between different nations but without intention of creating binding obligations are not treaties. However, they may have political effects. Means they may have some effects on the politics or how the nation is working as a whole, but if it does not has the intention of legally being binding upon those nations which are party to it, then it cannot be called a treaty. Because for being a treaty, that agreement has to have a binding force. कहते हैं ना कि कुछ like it is some prerequisites or essential conditions for an agreement to be qualified as a treaty. Okay, and that is, if we go a little above, that is this paragraph: binding, written, and states agree to act in a particular manner. So if it is not legally binding, that means one essential condition of it is not fulfilled, and so that particular agreement will not be called as a treaty. It will only retain the status of an agreement but not elevate to the status of treaty. Okay, so it may have some political effects because obviously the nations may have agreed upon that because of some political dynamics between them. Treaty need not be one consolidated document but may consist of more than one related documents. Means like we make a folder, right? We may have one document in that folder or some related files also. So similarly, for treaty also, it may be a combination of one document. It may be one document in which all the elements are there which are necessary for that issue. जिससे रिलेटेड ट्रीटी बनाई है, सारा मैनर, नेशंस के नाम और ये सब डिटेल्स अगर एक ही डॉक्यूमेंट में आ गया कंबाइन करके, तो इट विल बी वन कंसोलिडेटेड. अदरवाइज मोर देन वन रिलेटेड ऑल्सो कैन बी देयर एंड इट विल होली बी कॉल्ड वन ट्रीटी. Treaties may be drafted between states by their leaders or government departments depending upon circumstances. Means it may be that the head of the government has gone to sign or to ratify the treaty. For example, Prime Minister has gone. Okay. Or it may happen that a concerned department, like if it's related to environment, then Ministry of Environment के head गए हैं, right? Or if it's related to agriculture or some foreign services, तो मिनिस्ट्री ऑफ फॉरेन अफेयर्स का हेड गया है या उनका कोई रिप्रेजेंटेटिव गया है. ओके, सो इट मे बी एज पर द सर्कमस्टांसेस. मे बी दैट प्राइम मिनिस्टर इज बिजी समवेयर एल्स एंड ही कैन नॉट गो टू ratify. Or it may also happen that a particular treaty need not even require the ratification by or signing by the head of the government of a nation, but only the concerned departments or secretaries. So those persons will go to represent the nation, of course. Okay, so that depends upon what are the circumstances and requirements of that treaty concerned. How to adopt a final draft into a binding treaty. Now draft is something you can say a structure or a layout. Okay, and which is prepared about something. जैसे हम इवन इफ़ आई टॉक अबाउट कंप्यूटर, तो कंप्यूटर में प्रोग्राम रन किए जाते हैं, राइट, सॉफ्टवेयर्स में. तो उन प्रोग्राम का भी एक ड्राई रन या ड्राफ्ट बनाया जाता है कि ऐसे ऐसे स्टेप्स फॉलो करेंगे, तो बाय गोइंग इन दिस मैनर बाय सीक्वेंस वी विल हैव दिस पर्टिकुलर रिजल्ट. Okay, so even in law, when you file any petition, divorce petition or election petition, bail application, any such thing, then उसके भी ड्राफ्ट्स बोले जाते हैं कि हर एक पर्टिकुलर मैटर या इशू का ड्राफ्ट है, दैट दिस इज़ द वे, दिस इज़ द मैनर, दिस इज़ द स्ट्रक्चर और लेआउट इन विच any document or any application has to be presented. Like you write a simple application for leave, for example, छुट्टी के लिए आप जो application लिखते हो उसका भी एक particular draft होता है, structure होता है formal, which you have to follow, right? So final draft is like they are making a law on an international level, which is not easy, right? We are talking about very simple basic applications right now, but think about making a law for a particular country or for many countries of the world. So it is a complex way and complex thing to do in itself. So there may be a situation like इट इज़ नॉट मेड इन वन गो, एक ही बार में पूरा सही से नहीं बना, कुछ अमेंडमेंट्स हुए कि आप ये प्रोविज़न नहीं ये प्रोविज़न डालो, इट इज़ मोस्ट सूटेबल और इट विल बोर good results, right? So you enter this provision, you delete this, you amend this a little so as to suit the circumstances of today's time. And it may also happen that by reading the first draft which is made, हो सकता है कुछ सजेशंस या अमेंडमेंट्स उसमें सजेस्ट किए जाएं, या हो सकता है उस फर्स्ट ड्राफ्ट को बिल्कुल अलग तरीके से फिर सेकेंड ड्राफ्ट में प्रेजेंट किया जाए, पूरा ही उसको डिलीट कर दें फर्स्ट ड्राफ्ट को, राइट? एंड इट मे ऑल्सो हैपन दैट फर्स्ट ड्राफ्ट से सेकेंड ड्राफ्ट आने तक जितने भी डिस्कशंस एंड ऑल हो रहे हैं ऑन दैट ड्राफ्ट, उसको बहुत टाइम बीत जाए, ठीक है, इन डिस्कशंस. So by the time the second draft is prepared or is on the verge of being ready, by that time the circumstances, situations and whatever the political, economic, social conditions or the predicaments of people are, that is also changed, right? So now you have to cater to those changed circumstances also and then accordingly make the amendments in the bill or draft that you have prepared. So accordingly ऐसे changes होते रहते हैं and then second draft is completed and then उस पर भी discussions होंगे and then you will finally reach on to a stage which is final draft कि now this is final. ठीक है, जैसे हमारा बिल प्रेजेंट किया जाता है इन बोथ द हाउसेज ऑफ पार्लियामेंट, दैट इज़ ऑल्सो अ सॉर्ट ऑफ ड्राफ्ट जिस पे डिस्कशंस एंड ऑल में पार्लियामेंट कुछ चेंजेस सजेस्ट कर सकता है. And then the final draft, that is bill, is prepared and when it gets the assent of president, it becomes an act and that act is law which is binding on the citizens, right? So this final draft on an international level, when it is also has to be legally it also has to have a legally binding force, then how that binding force comes into picture. That is the meaning of this pink statement which is written in your books. There are a number of stages that are involved to convert a final draft into a binding treaty. The final text has to be adopted in an international conference by way of 2/3 majority. Like I said, to pass a bill in both the houses of parliament, there is a certain proportion of majority which is needed. And in what circumstances, what kind of bills, what majority is needed, that is specified clearly in the Indian Constitution, right? So similarly, if this final draft has to attain the binding force, has to be binding on the nations, then the majority required for that is 2/3, okay? And of what? Of the people present in that international conference. So states are called upon, draft is read so that everybody knows what are the contents of that draft, क्योंकि जब तक आपको पता नहीं होगा कि उस ड्राफ्ट में क्या है, किस चीज़ से वो डील कर रहा है, कैसे किसी एक पर्टिकुलर प्रॉब्लम का उसने सोल्यूशन ढूंढा है या निकाला है, एंड व्हाट फर्दर स्टेप्स हैव टू बी टेकन इन फ्यूचर इन रिगार्ड विद दैट सोल्यूशन टू द प्रॉब्लम एंड सो ऑन एंड सो फोर्थ. So the contents have to be read out to make the nations aware of, and so that they also have the knowledge that to what they are actually consenting to or for what they have been collected to attend the conference. Okay, so that is known as adoption by 2/3 majority. Then method to express consent to be bound by a treaty. Express consent means आप सामने से हाँ बोल रहे हो, that yes I agree to this. Okay, implied means by conduct. You have not directly said yes to a thing, but your conduct shows that you agree with that. For suppose if somebody asks you, will you go to shopping with me? Okay, and you say yes, I would love to. So that is express consent which you are giving to that act. If somebody says that let's go shopping and you do not say yes, do not say no, तो expressly आपने directly उस बंदे से कुछ जवाब नहीं दिया उसके इस क्वेश्चन को, but you get ready, you change your clothes, you take money and then you go ahead with him or her. So that is your conduct shows that you agreed with her or his proposal, and then you agree to do what he has asked to do. Okay, so that are the two types of consent, and this you will find in almost every law, whether it is domestic or international or even in domestic laws. जितने भी laws हैं उन सब में जहाँ जहाँ consent है वहाँ ये दो type of consent आएगा ही आएगा, express and implied. So here we are talking about methods to give express consent. Now consent is for what? That yes, I am ready to be legally bound by it. Now legally bound also means that if you are violating it, the legal consequences will follow, right? A state may express its consent to be bound by a particular treaty in certain cases by signature. That is the most express one. Signature hai, it is proof even for future references. It serves as a record, right, that yes, see, you have signed, that means you agree to it. So that is the express way, because it is clear, it is explicit on the pen and paper thing, right? Treaties may be given force by signatures of representatives who have been given the full power, that is authorization in writing from their state to be able to take decisions on its behalf. So as I said, it may happen that government of state, that is PM, is busy somewhere and is not able to attend a particular conference. So he may send the concerned department, or even the minister of the concerned department may not go, but anybody from that department, secretary or minister in charge, he or she may go to attend that, and it will be the representative of the nation as a whole. So by representation I mean that the state or the central government, because foreign affairs के matters central government ही deal करेगी. State government of any state is not authorized to deal with international matters, right? That is the domain of central government or union government to say. So it has the authority which is given to him or her by the central government, that you represent me, you represent India on that international domain in that conference which you are going to attend, right? And on my behalf you can take decisions, whatever is the need of the hour in that conference. जो भी नीड है उस हिसाब से जो आपको नॉर्मल प्रूडेंस से नेशन के लिए सही डिसीजन लगे वो आप उस समय उस कॉन्फ्रेंस में ले सकते हैं. ये क्लियर अथॉरिटी दी जाती है, एंड देन ओनली दैट पर्सन इज सेंट टू द कॉन्फ्रेंस. ओके, अदरवाइज उसका उस कॉन्फ्रेंस में जाने का कोई मतलब रह नहीं जाता अगर वो डिसीजन ना ले सके या एक्ट ना कर सके या उसे कोई अथॉरिटी ना दी जाए इस बात की, राइट? सो द रिप्रेजेंटेटिव्स और द, अगर पीएम है तो वो तो साइन कर ही देंगे. सो दैट इज़ द वे बाय विच द मेजॉरिटी इज़ काउंटेड. जितने साइन होंगे, अगर 2/3 का साइन हो गया तो मतलब मेजॉरिटी मिल गई. दैट इज़ अ पार्ट ऑफ कंसेंट ओनली, नो? सो इन दैट वे दिस सिग्नेचर वर्क्स. एंड anyways also signature is a full proof evidence that a particular person knows the contents of these documents and he has agreed to whatever was written in that document, and then only he has signed. assume यही किया जाता है ना अगर आप किसी डॉक्यूमेंट पे साइन कर रहे हो. so similar is here also. so the authorization part is very important, and everything of the government is done in written, so that again it serves as a record for future purposes. also it acts as an estoppel against the person कि बाद में वो मुकर ना जाए. तब आप वो रिटन डॉक्यूमेंट दिखाओगे कि देखो आपने इसमें ऑथराइजेशन दिया था, इसीलिए उस ऑथराइजेशन को यूज़ करते हुए मैंने ये डिसीजन जो मुझे सही लगा फॉर द नेशन वहाँ पर लिया है. ठीक है, बिकॉज you are also bound by it. Once you have given consent, once you have signed, you are bound by the contents of the document. ठीक है, इसलिए सोच समझकर रैशनल प्रूडेंस के साथ आपको डिसीजन लेना होता है. Because you are not only doing something for your own personal benefit, but you are representing the whole nation. तो crores of people living in that nation के लिए आप रिस्पॉन्सिबल हो जाओगे. तो उतनी बड़ी रिस्पॉन्सिबिलिटी को ध्यान में रखते हुए ही कुछ ऐसे एजेंट्स या रिप्रेजेंटेटिव्स सेंड करती है गवर्नमेंट विद द ऑथराइजेशन गिवन टू देम. देन कंसेंट बाय एक्सचेंज ऑफ instruments, that is documents. Instrument is what? A type of document only, which contain the terms agreed to by both sides when these instruments provide that on such exchange they will be in effect. That means some documents, exchange means मैं तुमको दे रहा हूँ तुम मुझे दो, यही तो होता है exchange का मतलब. तो यहाँ पर documents का exchange हो रहा है by both the sides, to and fro, right? And it is done when these documents ensure that when the exchange has taken place, then only the contents of the document will be executed or they will come in force. तो अगर उस इंस्ट्रूमेंट में लिखा हो कि सर्टेन डॉक्यूमेंट के एक्सचेंज पर ही द प्रोविजंस विल कम इनटू इफेक्ट, दे विल हैव द बाइंडिंग फोर्स, तो डॉक्यूमेंट का एक्सचेंज करना तो ज़रूरी हो ही जाएगा, राइट? बाय रैटिफिकेशन. Ratification is the act by which a state establishes its consent to be bound by a treaty on the international plane. Okay, so the consent is that okay, I will now onwards be bound on the provisions of this treaty. So that is a way of giving the consent by state. Ratify. This was initiated as a measure to ensure that representative who signed a treaty had due authority by seeing whether the state agrees to ratify the same. Okay, so just that you have signed it. अब आपको कैसे पता चलेगा कि अथॉरिटी उस रिप्रेजेंटेटिव की थी या नहीं ऑफ अ पर्टिकुलर नेशन? सो टू फाइंड आउट दैट द रैटिफिकेशन प्रोसेस वाज initiated so that the international organization or the bodies at the international plane, they are also aware of the due authorization by the concerned nation's government to the representative who has attended that conference. कि उन्होंने साइन तो कर दिया, ठीक है. सी इट इज़ रिटन रिप्रेजेंटेटिव हु साइंड अ ट्रीटी. ओके, तो उन्होंने साइन तो कर दिया, बट उनकी अथॉरिटी थी या नहीं? क्योंकि अगर बिना अथॉरिटी के किया है, देन द गवर्नमेंट विल नॉट बी बाउंड बाय द साइन ऑफ दैट रिप्रेजेंटेटिव. ठीक है, अगर उस रिप्रेजेंटेटिव की अथॉरिटी नहीं थी टू टेक एक्शंस और टू टेक सम डिसीजन ऑन बिहाफ ऑफ द गवर्नमेंट, दैट अथॉरिटी इज ऑल्सो गिवन बाय द गवर्नमेंट. तो गवर्नमेंट साइन ऑफ द रिप्रेजेंटेटिव से बाउंड नहीं होगा, बिकॉज उन्होंने ये अथॉरिटी नहीं दी थी कि जाओ तुम जाकर मुझे रिप्रेजेंट करो और मेरे बिहाफ में डिसीजंस लो. तो उसने कैसे साइन किया? तो अगर मैंने तुमको नहीं बोला कि जाओ जाकर मेरे बिहाफ में डिसीजंस लो, और तुम जाकर बोला है कि हाँ जो है दिस पर्सन इज़ रेडी टू डू माई फ्रेंड इज़ रेडी टू डू दिस थिंग, जैसे तुमने प्रपोजल दिया था वो तैयार हो गई है तुम्हारी बात मानने को, लेकिन मैंने नहीं कहा था कि तुमसे जाकर उसको ये बात बताओ दैट आई एम रेडी. आई हैव नॉट गिवन यू दैट अथॉरिटी टू टेक डिसीजंस ऑन माई बिहाफ. तो तुमने कैसे ले लिया? आई एम नॉट बाउंड बाय इट, राइट? वेरी सिंपल थिंग. उसी तरह से अथॉरिटी होना बहुत ज़रूरी है इन रिटन. वो कैसे पता चलेगा? अगर कंट्री शोज टू द इंटरनेशनल ऑर्गेनाइजेशंस एंड टू द इंटरनेशनल फ्रंट that yes, I am obeying the provisions of this treaty. और वो ratification कैसे show होता है? If the legislature of that state adopts the provisions of that treaty, maybe all the provisions or some of the provisions as it is suitable for that nation's circumstances. Okay? Ratification differs from country to country, but usually requires a sign that state consents to follow the provisions of the treaty. As I said, this could be established by assent by president or require a vote of majority in legislature of the state. As I said कि कंट्री को अपने लॉ में कहीं ना कहीं या तो एक नया लॉ बनाना पड़ता है या एग्जिस्टिंग लॉस में कुछ चेंजेस करके प्रोविजंस ऑफ द ट्रीटी को इनकॉर्पोरेट करना पड़ता है. सो एज टू शो दैट येस वी आर फॉलोइंग द प्रोविजंस, और अगर ये चीज़ शो हो गई दैट दे हैव फॉलोड द प्रोविजंस ऑफ द ट्रीटी, दैट मीन्स कि जो रिप्रेजेंटेटिव ने साइन किया था उसकी अथॉरिटी थी साइन करने की, तभी तो गवर्नमेंट बाउंड हुई ना उसके साइन से. उसने साइन करके आया, गवर्नमेंट को आके बता दिया कि हाँ मैंने हाँ बोल दिया है उस ट्रीटी को. ठीक है, तो अब गवर्नमेंट सोचेगी कि हाँ चलो अब देखें ट्रीटी के क्या क्या प्रोविजंस है. अब उसने हाँ बोला है, मैंने अथॉरिटी भी दी थी, तो नाउ आई विल बी बाउंड बाय इट, जो वो मेरे बिहाफ में एक्शन करके आया है. राइट, तो फिर वो जो है अपने स्टेट में, कंट्री में वो प्रोविजंस अप्लाई करेंगे. ठीक है, और उस एप्लीकेशन ऑफ प्रोविजन से इंटरनेशनल फ्रंट को पता चल जाएगा दैट हाँ इट इज़ रैटिफाइड, दैट मीन्स द स्टेट हैज़ अग्रीड टू बी बाउंड बाय द ट्रीटी. ठीक है, सो बाय द कंडक्ट दिया वहाँ पर एक्सप्रेस कंसेंट है, लेकिन बाय एसेंट ऑफ द प्रेसिडेंट बाय वोट ऑफ मेजॉरिटी इन लेजिस्लेचर, दैट मीन्स इट इज पास्ड बाय लेजिस्लेचर एज अ लॉ. राइट, वोट ऑफ मेजॉरिटी इन लेजिस्लेचर तो तभी मिलती है ना जब किसी चीज़ को हम किसी बिल को हम लॉ बनाने के लिए पास कर रहे हो. राइट, सो दैट मीन्स इट इज पास्ड बाय द लेजिस्लेचर. और असेंट भी तभी दिया जाएगा जब बिल हैज़ टू बी कन्वर्टेड इनटू एन एक्ट. Here state means country, not the states of India. Okay. Multilateral treaties involving a number of countries, ratification is the most preferred method of expressing consent where one party collects ratification of others. So multilateral treaty means हो सकता है that there is one country which is hosting that conference, okay, and it will collect the consent of all the other countries which were part of that conference. Okay, generally considered to be the most accepted as they are in written form and have been expressly assented to by states party to the dispute. Okay, so ratification is one of the most accepted ways of obtaining the consent, of ensuring that the consent of the state is given, and it is also legally bound by the provisions of the treaty. It has accepted the provisions and ready to implement it in its own domestic laws of the nation. And the written form is the most credible one. The reasons I have already told you many a times, and this is the way in which the explicit or express consent is also ensured of the nations. Okay, now customary law we will be taking up in the next video. Thank you so much.